Welcome to the law offices of Sabrina Li. Many people believe that sponsoring a parent for a green card is one of the simplest immigration cases. But this case shows how a Communist Party membership from decades ago almost led to the separation of an entire family.
Sabrina is a certified immigration law specialist. Only 1% of attorneys in the U.S. can earn this recognition. If you are in a similar situation, please call 213-375-8096 to schedule a consultation with us.
Our client was living in the United States with his daughter's family on a B-2 visitor visa, and as the parent of a U.S. citizen he was eligible to adjust status to permanent resident from within the country. He needed a coordinated plan from the very beginning, so our firm handled the matter comprehensively and filed the Form I-130 immigrant petition together with the Form I-485 adjustment of status application in July 2025. Filing this way allowed him to remain in the United States with his family while the case was pending. On paper, this looked like a straightforward case: a parent of a U.S. citizen, an immediate relative eligible for a green card. But one fact in the client's history changed everything. Under Section 212A3D of the Immigration and Nationality Act, a person who is or has been a member of the Communist or any other totalitarian party can be found inadmissible to the United States. For a green card applicant, that is not a minor footnote. Left unaddressed, it can stop an otherwise approvable case in its tracks. Procedurally, an inadmissibility finding can read like a single line in a file. For this family, it put at risk everything they had built together over more than a decade. The client was the anchor of a close, multi-generational household, living with his U.S. citizen daughter, her husband, and their young child, for whom the client and his spouse were the only living grandparents. The family stability was not theoretical. During an earlier period of medical and financial crisis, the client and his spouse stepped in as full-time caregivers for their grandchild, which allowed the daughter and her veteran husband to keep working and keep the family afloat. If the inadmissibility issue were mishandled, the family faced an impossible choice: separating or uprooting U.S. citizen and veteran family members to a country where the veteran could not access the care he relies on. Rather than wait for USCIS to raise the CCP issue later in the process, we addressed it head-on by preparing a Form I-601, application for waiver of grounds of inadmissibility, as part of the original plan. That choice let us control the timeline and present a complete, well-organized record from the start, instead of scrambling to respond after the government flagged the problem. A successful I-601 waiver is one on the human facts. We assembled a submission that allowed USCIS to see the client not through the narrow lens of a decades-old party affiliation, but through the full context of his character, his ties, and the real-world consequences for the U.S. citizen and veteran family members who depend on him. We also addressed, factually and respectfully, that he posed no security concern, a retiree with no political or party activity whose loyalty runs entirely to his family. Because this was an adjustment of status case, the client attended an in-person interview at a USCIS field office. In a matter involving a totalitarian party ground of inadmissibility, this interview can be decisive. The officer questions the applicant directly about how and why he joined the party, and what membership actually involved. Preparation mattered. The client was ready to explain a complex, decades-old history clearly, consistently, and honestly, so the officer could see the full and accurate context rather than a label on a form. When the officer asked what interest supported approval, the answer was simple and true: keeping the family together. By the end of the interview, the officer indicated he was inclined to approve. Shortly after the interview, in January 2026, about 6 months after the case was filed, USCIS approved the Form I-601 waiver, formally waiving the ground of inadmissibility tied to Communist Party membership. The Form I-485 was approved within days, granting the client lawful permanent resident status on the foundation of the already approved Form I-130, which established the qualifying parent-child relationship. This approval meant far more than closing a file. It allowed the family to stay together in the United States, to keep the grandparent who anchors their household, and to move forward without the cloud of inadmissibility.
If you or someone you know has been affected by a similar situation, contact the law offices of Sabrina Li at 213-375-8096 or email us at info@sabrinali.law.
Our legal team will do everything in our power to handle your case. Your American dream, our commitment.